Ground to cover. Let's see. Are we set recording? Yeah,
yes,
there we go.
We are.
Okay. So we have a lot of ground to cover because we're gonna talk about what underwriting looks for when we have a death in our chain of title, if we're in the middle of a divorce proceeding, or there may be issues from a divorce that happened a few years ago. And I do have some state-specific information in here, so we're going to hit the ground running and make sure that we get everyone some a good credit hour. So we're going to start with the death side, the estate issues, which is going to make up the bulk of the discussion because there's just so much that happens with an estate, with a probate. And so they're very common issues. I mean, I don't think there's a single day that goes by where I don't see dead people in an email. It's a joke that I use quite a bit when people ask me what exactly like I do in my role. And I basically tell them, well, I look at Find a Grave, I look up obituaries, I play private investigator, and basically look for dead people every week. And it's just because it's such a common title issue for us to run across. And it's not always something that the parties to your transaction think is going to be a big issue, right? They don't always realize that because, mom died within the last 2 years in Alabama, 5 years in Arkansas, 3 years, 90 days in Mississippi, that they need to go through either probate or administration proceeding. They just think they have the property and that they have the ability to sell it. And so that becomes problematic, obviously, because we'll get a contract with someone signing as the seller, and they may not be the individuals entitled to own the property under the law. And so that's one reason why, there's always some misinformation, confusion on the parts of the sellers, the lenders in those transactions. Let's see. So I put this first slide in here, terminology. That's because when you're communicating with us on the underwriting side, when you have an issue, if we're using the correct phrases, we can usually kind of get to what we're going to require a lot easier. And the reason for that is because it's easy to say, well, hey, I have an estate issue, but there's no open estate. There's no estate proceeding filed, or we're talking about someone says I have a probate issue, but there's no will. So the terminology is helpful for us just to understand what's going on and what the correct requirements are going to be. So all three of the states that I cover, your states, see a state very similarly. So while it can be treated as an entity for tax purposes, right? It's technically not considered a legal entity. It's more like a fiduciary vehicle, right? So the way that title vests after the property owner dies is it either vests immediately in the heirs at law, or it's subject to the estate to probate the will and determine who under the will takes title to the property. But it relates back to the date of death. So the estate doesn't technically own the property. It's just the vehicle to get it through the claims process and proving the will to determine who takes, or if there needs to be a determination of heirship, determining who the heirs at law are. So when we talk about probate, we're talking about proving the will. So the word probate, outside of being a reference to a form of court, obviously, we're talking about proving the will and having a state proceeding revolving around that will. If we're talking about intestate, we're talking about dying without the will. we're dealing with an administrator or an administratrix. That's the technical term given to the personal representative that gets appointed in the administration proceeding. So all of this terminology just works out again when we're trying to figure out what we need to do to get to the closing. Test date, dying with a will, and then we're looking at the terms of the will, executor, executrix, and then we're talking about who the devisees under the will are, who's going to take title. So again, it's not always clear. Just looking at the contract, if we have an estate issue, until we've done a little bit of research and we realize that our seller's not in the chain of title, or they tell us, well, I got this property from mama. So at that point, we're trying to figure out which route to go. At what point did mama die? Are we in the claims period? If so, is there a will? Are we able to probate that will? If we don't have a will, then we're looking at heirs at law and whether or not we need to have an administration because of the claims period. We might find that there's a break in the chain of title where one of the grantees in a deed back in the chain does not convey their interest. Well, at that point, we're wondering, was there a death? If so, were our requirements met to ensure title going forward? Was there an estate proceeding? Did the final order of distribution give the property to the grantor in the next deed? And that's a little bit of a point of preference with estate attorneys, I know, also underwriters, and I'll mention it real quick. So if there is an estate or an administration in your back chain, and we have a break in the chain of title because there was never a deed from the personal representative or the administrator, if we have that final order, we can always record the final order of distribution, because that vests title pursuant to either intestate succession law or the administration or the probate of the will and vesting the property in the devisees. So we don't always need that deed out of the estate, but we definitely need the final order if not. So again, when we get into one of these scenarios where we see there's an issue, a possible estate issue, then we're asking if there is a will. So if there's a will, there's a way, right? So the first thing we need to look at once we have that will is how long ago and I keep saying mom, I don't mean to pick on the mamas out there, but how long ago did mama pass away? Because there are in some states time limits to probate a will. So in Alabama, we have a 5-year period from the date of death to probate that will. Now there are exceptions for like fraudulent conveyance. Those are rarely coming up, and if they do, it's usually by court order. There has to be a finding that there was a fraudulent concealment of that will. So it's something that we typically don't have to worry about. But there is that 5-year term. Arkansas, same term limit. So we're looking at 5 years from the date of death to be able to probate that will. In Mississippi, one thing I really hate is that there is no time limit to probate a will. So if property was vested in mama, mama passed away 20 years ago, and they decide, hey, we want to probate the will because this long lost brother or sister were not they were not a devisee under the will, they can technically do that. So that can be that can definitely be a problem. It only comes up in rare scenarios, but it is an interesting issue that we have to take a look at.
Zach, we got somebody raising their hand. I'm sorry, it just says MTG.
Yeah.
Hey Zach, it's MTG crew.
Hey George, how are you?
Glad to see it. Glad to see your PJs looking good.
Hey, what's the question?
what happens when, you know, you do an heirship determination and, you get 3 or 4 heirs and you have them all sign, and then the will pops up 4 years after closing and vest everything in the Baptist church? Is that why we have title insurance, or how does that practically work out?
Right. If there is a third party that paid consideration, real consideration for the property, and we're after the claims period, that's a low risk scenario where there's case law that protects the bona fide purchaser, who didn't have notice there. At that point, if there was an estate opened after the fact, and there were claims of creditors or some other interested party, we would, in that case, the court usually looks at the heirs that collected the proceeds from that sale. And I'll mention it later, but one way that we try to get around that from an underwriting perspective and to limit risk to all of the parties is if we're always going to ask if there's a will in Mississippi if we have a deceased vested owner. And if there is a will, but they believe there's not enough assets, they're fine with all of the heirs signing. In that case, we still want to make sure there's not another interested party, a different devisee under the will that could take. And we're going to have a provision or a recital in the deed out of all of those parties, heirs at law and any other devisees, that not only are they granting their interest, but they're renouncing the will and attaching the will to the deed. And so that's a way to later make an argument that it would be inequitable for them to try to pull the asset back into the estate.
Okay. Thank you.
Yep. So the one place where those time periods for Alabama and Arkansas get a little quirky is with ancillary proceedings. So if there is a property owner that wasn't a resident of the state, and their estate was probated in their home state, there's a chance that even though we're past that 5 years, we could still have an ancillary proceeding to probate that will. So in Arkansas, definitely, if it was probated in another state according to that state's law, we can have an ancillary proceeding despite being past the 5 years. In Alabama, I put maybe, and that's because the will in the foreign state would still have to have been probated within 5 years for an ancillary proceeding in Alabama to take place. Not as gracious in Alabama with ancillary proceedings. So once we have the will, we determine that we're in the time frame to probate it. They're going to go forward with a probate proceeding. Then we're looking at the terms of the will, because we want to know from the underwriting perspective, do we have our real property being specifically gifted or devised to certain individuals? Or is it considered part of the residue? It's not specifically referenced. And the reason that's important is because it can impact who we're going to require to sign at the closing. And that depends also on whether we have a power of sale in the will, which we'll talk about in a little bit. But if we have a specific devise, then in that scenario, if we have a power of sale with the personal rep, we don't have to have a court order, which we'll talk about. We would have those specific devisees also convey their interest. That way, we're making sure there's no conflict. There's not going to be any kind of contest to the sale, because technically, if the will's probated, title is going to flow to the individual that specifically gifted the property. Now, if it's a residue gift or devise, then we can get a little bit more creative if we need to, in just having the personal representative sign under a power of sale. But we usually want to look a little more closely at the will. So at that point, we're trying to determine if the personal representative has to seek a court order to sell or if they have a specific power of sale under the will. So it depends on the language that's used. In some cases, you'll see the personal representative be granted a power of sale, but it only relates to a statutory ability to sell for any claims and debts. So they're given a power of sale in the will, but only to the extent that there's not enough personal property to cover the debts of the estate or to cover any claims. So we want to make sure that we do have a specific power granted to our personal rep that they're allowed to convey, sell, contract, encumber the real property that's passing through the estate. So I put here, and I already touched on it, even with a good power of sale, if it's a specific devise, we want to make sure that those devisees join in to avoid conflict. Also, the note here, and this does come up occasionally, where there has been a final order closing the estate. When that happens, that personal representative has lost all authority under the will to then convey as a personal representative. So we want to make sure that our estate is still open if we're accepting an executor or executrix conveyance. So if we have a power of sale, this is kind of our general standpoint on our underwriting guidelines. We would prefer to have the personal representative and the devisees sign together if it's residue property. So I already said if it's a specific devise, have that devisee join the personal rep. If it's a part of the residue of the estate, we prefer, again, have all the parties sign, no contest, right? Well, it may be impossible for everybody to make it to the closing, which happens. There may be devisees under the will that live out of state or can't make it because of health reasons. That's where, you kind of have to have your feelers up, make sure that we know that everyone's in agreement. There's no known controversy. There hasn't been any kind of contentious motions filed or appearances made by any of the devisees. And again, make sure that power of sale is crystal clear. So what if we don't have a power of sale? And this applies to if we're dealing with an administration of an intestate estate. There is no will. So there's been a court-appointed administrator. Well, in either of those scenarios, we have to require a court order. There have been some times where we have bent that rule somewhat, but it really depends on who's coming to the closing, at what stage are we in the proceeding? Are we past the claims of creditors? Where's the proceeds going in that situation? So there is some wiggle room there, but in general, we want to see a court order because, again, the assets would be subject to the estate proceeding, definitely the administration proceeding, if we don't have a power of sale. So for Alabama, you'll generally see the court order reference, or the petition and the court order reference it, the sales for the payment of debts, or it's for division of the estate assets or division of the property, because there's no other way to do it. There's no other way to divide the property between the heirs or the devisees. And so that court order acts to divest the heirs and devisees of their interest in the property and allow the personal representative or the administrator to convey the property per the court order. Now, there is a confirmation hearing that takes place 10 days after the report of the sale gets filed. But we generally don't have to look too closely at that because we need to pay attention to the appeals period for that order authorizing the sale, which in Alabama is 42 days. Now, if we have all of the interested parties in the estate joining in the petition and there's no conflict, then we may be able to close the transaction without having to wait out that time frame. But if we're in a position where not everyone's agreeing, certain parties couldn't be found, then we're taking a closer look at that appeals period. In Arkansas, similar concept. When we have a court order for division purposes or because of a insolvent estate, there needs to be a report of the sale made within a 10-day period, and then the court will confirm it. If there's in an estate proceeding in Arkansas, we have a 60-day window where there can be objections that would prolong our appeals period, our typical 30-day appeals period, even from the final order of distribution. So again, we're looking to see who all is involved at that point and if they've joined into the petition. So Mississippi is a little bit quirkier because there's been case law that's been really detrimental to relying simply on a petition and order of sale. The courts have basically said that unless four statutory procedures, which I have listed, have been referenced in the petition, and if we haven't included all of the parties in interest, then the court order could be invalid or void. So the first of those scenarios is that the sale of the real property is in preference to the personal property, and it's in the best interest of the interested parties. That one is kind of the catch-all that I see a lot of. It's in the best interest of the parties. Everyone's either been given notice or they've joined in. There's not a lot of risk for conflict there or set aside there. If the decedent had entered into a contract for the sale of the property prior to death, which we'll talk about in the next slide, and if the estate is insolvent, or basically what the next two come down to. Those require that it specifically state that it's insolvent, or the order and sale will be invalid. So again, when we're looking at an order, we're just wanting to see who could potentially contest it if we're not past an appeals period. Contracts of the decedent. This is an interesting kind of issue that can come up occasionally. But if you have a contract that the title vested owner entered into before they passed away, technically the personal representative of the estate or the administrator is authorized to continue to fulfill that contract, as long as the contract hasn't terminated by its own provisions. They have the authority to do that. Now, in Arkansas and Mississippi, a court order is still required to acknowledge that the personal representative is fulfilling the contract and selling the property free of the estate claims. Alabama is a little bit more forgiving, but we generally do want to require a court order recognizing the sale under the contract to avoid any conflict. But again, we can always take a look at the facts and see if there's any risk in Alabama if we go forward without having the order that's recognizing action under the contract. So alternatives to a full probate. We're really looking at three scenarios. So Arkansas has what is a small estate. Mississippi had something similar at one time before we got rid of it there. But in Arkansas, we have something called a small estate, where essentially we have an affidavit that gets filed, a small estate affidavit that is supposed to name the heirs at law of the deceased title vested owner. It's a very self-serving affidavit. It also has some questionable statutory interpretation in that the value of the estate has to be under $100,000, but the homestead property is exempt from that calculation. And there's been some question as to whether it's the homestead exemption amount or if it's just the homestead property completely. I read it. I know many of our competitors read it that the homestead property itself, the total valuation for that homestead property is exempt from the calculation. So we can get comfortable in that scenario. But if there's real property, which there should be if we're dealing with the small estate, they still have to publish notice to creditors as if it's a full estate. So the problems that we run into with the small estates, we have the self-serving affidavit. It's very common to see one person that was married to the title vested owner thinking that they should get the property, and they only list themselves as the distributee under the small estate affidavit. So we still require 2 heirship affidavits, which we'll talk about later, but it should set out who all the heirs at law are under Arkansas law, as those are the parties that need to convey the property. The code provision that allows for small estates in Arkansas does allow for attaching the will if there is one to the small estate. The problem with that is that it's not clear enough to state that the will is actually proven as valid. So the intent in that law allowing for the will to be attached to the affidavit is to show if there's any parties that are not an heir at law that might have an interest in the small estate procedure. It is not proving the will as being valid. So in that scenario, they can attach the will to the small estate affidavit, but we would still require heirship affidavits and any heirs not referenced in the will to join in the conveyance. So that's a big issue that we've had, and there's definitely been some claims issues with that. In Mississippi, we have a procedure called probate as muniment of title, and I'm not a huge fan of that. I used to do that a little bit when I was in private practice and a litigation attorney. It's really only beneficial to us if we're past that claims period that we'll talk about a little bit later, but the 3 or 90 days claim period in Mississippi, all that proceeding does is prove that the will is valid. It does not have a vehicle to publish notice to creditors. And the fact that we have no time frame or time period on the ability to commence a full probate action, that's kind of the concern there is, okay, well, is there a chance that they're going to try to come back and do a full probate if they find another asset of the estate? So we generally ask some questions about what do we believe is in the estate? What's listed in the will? Is it really just the real property is the sole asset? Are there no debts or concerns there? So we take a look at that. The third option here is the ancillary probate proceeding. So Mississippi finally added an ancillary probate proceeding. Man, when was that? 2020, I believe. And unlike Alabama and Arkansas, Mississippi's proceeding is still very close to being a full probate. It basically just takes off the necessity for the initial hearing to prove the will and grant the letters. It allows for that foreign order granting letters and probating the will to be entered of record in Mississippi. But then at that point, you just go to publishing notice of creditors and administrating the estate as if it was a full-blown estate. In Alabama and Arkansas, it's a little bit of a shorter version, but we're still having to look at our claims period and publish that notice. But if we do have a scenario where we're in the claims period, or even if we're outside of it, as long as in Alabama, it was initially probated in the foreign state within that 5-year period, we're looking at an ancillary probate proceeding in our home state because we would need that in order to give some authority as to the property in our state. As just kind of a quick aside, this comes up occasionally when we have someone from out of state say, well, hey, I've got a court order from, and I actually had this happen, but I had a court order from Joliet County, Illinois, so in Chicago. So essentially, a man who owned quite a bit of undeveloped property in Mississippi had passed away in Chicago. They had administered his estate and found that he had no heirs at law that could be determined. So his real property, including the real property in Mississippi, then escheated to Joliet County, Illinois, which I just find to be hilarious. So the call was basically, hey, Joliet County, Illinois owns property in Mississippi. I need you to insure this transaction. Put me in touch with an agent. And of course, my response was, don't you think the state of Mississippi would have a problem with basically another state owning property in the state? That's not how the law works. So we still have to domesticate an order and an ancillary proceeding as a way to get to that point. So no will, no problem. Question marks, definitely. We're dealing with an intestate estate. So in that scenario, that could be a lot more work on our end, depending on if there is an administration happening or a probate estate attorney involved that can be helpful. But if there's no will that can be probated, then we're having to look at our state law to determine who has an interest in the property. And it can get very complicated depending on if there's a spouse, children, surviving parents, siblings. It can go for quite some time before we get to a scenario like that Chicago scenario where it then flows to the state. But if we're in the claims period, we need to still go through that administration proceeding and have a determination of the heirship. I know some judges in Alabama and Arkansas, some chancellors in Mississippi will actually have within that intestate proceeding an order that determines the heirship. If there's not, then we're kind of looking to see, okay, well, how did we figure out who the interested parties are? Who are the heirs? Again, kind of keep your feelers up, make sure that nobody's getting shortchanged in that scenario. And then, of course, we'd have to get an order to sell the property. If we're outside of the claims period, though, we're looking for heirship affidavits. So we're outside of, and we'll talk about the claims period in a little bit, but we're outside of that window. What do we need from an underwriting perspective? We're looking to record at least 2 heirship affidavits from disinterested and unrelated persons. Now, that can get difficult depending on when the title vested owner passed away. So depending on that time frame, and if you can at least get one heirship affidavit from a disinterested unrelated party, we might accept one from a relative that doesn't have an interest in the property by our intestate succession laws. So that can be fluid, but that's the general requirement. We want to make sure that they knew them during their lifetime. They didn't, gain knowledge about the deceased owner after they passed away. And then I sometimes get asked, okay, we can't get anybody to do a affidavit of heirship that's not related. In that case, my question is usually, okay, well, how long ago did they pass away? In my mind, once we kind of get towards the 20-year mark, if someone's been passed away or dead for 20 years, once we get close to that 20-year mark, can we find an obituary? Can we use things like Find a Grave, Ancestry.com, look at federal census information? What can you give me so that we can get comfortable that we're dealing with all of the heirs? The problem with that scenario is that we usually have to take an exception to a break in the chain of title and give affirmative coverage, because there won't be anything in the public record, there won't be anything in the land records that evidences heirship. And so we would take that route to limit exposure, limit liability, and then also by doing that, we keep other insurers kind of off off our back. We keep people from knocking on the door because we took exception to the issue, but we felt comfortable giving that affirmative coverage based off the information that you all gained. So the next 3 slides are my best finds for flowcharts for intestate succession. And I'm not going to go completely over these, but I did think it would be beneficial for you to have. If something falls outside of this, or in any of the states, if you have somebody that passed away in the 60s, the laws oddly kind of nationally started to change a little bit by how we looked at heirs at law and who was next in line in the 60s. So it does change once we get to that point. But for anything recent, these flow charts should be applicable. I did want to note on the Arkansas flow chart, it does not mention a dower curtsy interest, which I'll talk about in a little bit. So I added that note in here that basically if there are children, you still have to take into account the dower interest of the spouse. Arkansas, I believe, is the only state in the country that still recognizes a dower interest. And then for Mississippi, no fancy table here. It's just a listing of who takes. Once you get past that blood relatives of the highest degree, like I said, if there's no court order determining that there are blood relatives or any potential unknown heirs, then the property will fall to the state. And here's the requirement language that you can use for an heirship affidavit if we're in that situation where we're past the claims period for our states and can get comfortable going forward with heirship affidavits. The claims period. So the claims period changes depending on which version of the estate issue we're dealing with. If there's a will and we are in that 5-year period in Alabama and we're going to probate that will, then we're looking at claims of creditors after our publication of notice. So in Alabama, notice gets published to unknown creditors for 3 consecutive weeks. And at that point, we're looking at kind of our timing there, because our claims have to be presented within 6 months of the grant of letters to the personal representative, or within 5 months from the date of the first publication of notice, whichever is later to occur. And then known creditors have 30 days after receiving actual notice. It is a good idea when in this scenario, in a claims period, that we make sure that our title affidavit that may be signed, or a personal representative affidavit, states that there are no known actual creditors, or that all actual known creditors have been given actual notice. For an intestate estate, claims have to be filed with the probate court to force an administration within 2 years of the date of death. Which is fantastic. It's the shortest period of the 3 states that we have. In Arkansas, if we have a will that's been probated, we have a 2-year publication, 2 consecutive weeks of publication of notice to unknown creditors, and claims have to be presented within 6 months of the first publication of notice. Claims of known creditors have 2 years if they're not given actual notice. For an intestate estate, it's 5 years, which is the longest of the 3 states. So the same time frame as being able to probate the will, if there is one. So even if there's not a will and we have an intestate estate, we still have a 5-year window where we may have to administer the estate and have a determination of heirship. In Mississippi, we publish notice to unknown creditors for 3 consecutive weeks, similar to Alabama, and our claims have to be presented within 90 days from that first publication of notice. Intestate, a little bit funkier because it's an odd number, but we have a 3-year, 90-day window to present claims or to force an administration by presentation of the claim. So what if we're trying to close in the claims period? Each scenario is a little bit different, for sure. So always feel free to reach out and we'll see what we can get comfortable with. But generally, we're either talking about closing the transaction and escrowing all of the funds until the end of the claims period, which I've actually had some agents who have escrowed funds for multiple years, which is crazy to me, but more power to you. If you don't mind having somebody banging on your door to try to get their money because that period hasn't run out, have at it. I just hope that the escrow agreement's very strong, very particular about who that money belongs to during that time frame and when it can actually be released. The second option, obtain a court order for the sale of the property and specifically require where the funds are to be dispersed. If we're in the claims period, we really want to see that court order say that the proceeds of the sale are to be paid into the probating court or the estate attorney's trust account and for further disbursement, for future disbursement or payment of future claims, if any. So we want to make sure that there's no issue with how the funds are going to be handled on your end. Another option is to obtain an estate or probate bond if available, but it does require that there's actually an open estate or administration proceeding. And then finally, obtain underwriter approval to rely on an indemnity of the personal representative and proceeds being paid into either the court or the estate attorney's trust account. That's kind of our wiggle room situation. So if you have maybe a low risk scenario or an ask to close during the claims period, you want to discuss it, feel free to reach out. Here is the standard claims requirement. This has an affidavit aspect to it that the personal representative or administrator has to note that they have reached out to any known creditors. Also keep in mind that we need to get proof in Alabama that Medicaid was given notice by certified mail. And we also want to make sure that we're past that 30-day window for a response. And that's 30 days after they've received notice. So we want to make sure that there's not a possibility for a Medicaid lien in Alabama. In Arkansas and Mississippi, generally, they have to file the claim of their own accord. If there are any claims that have been filed, we have to require payment and cancellation of those unless we know that the proceeds of the sale are by court order being paid into the court to later pay off claims. And that occasionally comes up if they're going to contest the claim. Liens on heirs and devisees. So this comes up a bit because parties to a transaction occasionally want to argue, well, this is inheritance. My liens don't attach to this, which I think is, I think it's funny because the whole concept is in all 3 states is that title flows at the time of death. So it descends at the time of death. So if there's not a will, title vests in those heirs at law immediately at the time of death. Now, obviously, if we have an insolvent estate where we're divesting the heirs of their interest in the property because we have to pay off certain secured liens against the property and claims against the estate debts, then that's a different story because we're getting a court order to divest the heirs or the devisees of their interest in the property. Otherwise, title's still flowing through them. Heirs liens do attach to the property because, again, goes back to the date of death. And we do not look favorably on disclaimers in that situation. Now, there are scenarios where there will be a filed in the probate proceeding family settlement agreement in Arkansas is typical. There may be a file disclaimer in a probate proceeding in Mississippi per statute, and that may also be favorable, but generally we don't favor disclaimers. The law's not fantastic in Alabama in particular for disclaimers to avoid heirs liens. So if you have one of those issues come up, feel free again to reach out and we'll take a look at it. So the last thing that I have on death and estates before we get into, the really romantic topic of divorce, beneficiary deeds, transfer on death deeds. I've been hearing a lot from both land title associations and the bar in Alabama about needing transfer on death deeds. I hate them. They're not great. They're a terrible idea. And let me tell you why. It takes years for them to get to the point where we could rely on title being vested per one of these deeds at death and be able to close on a transaction almost immediately after. Arkansas has finally gotten to that point. The reason for it is because when these get passed by the legislature, when there's a vehicle for these beneficiary transfer on death deeds, they typically still have to keep them subject to claims of creditors. Otherwise, they would never pass. And what they do is similar to what Arkansas does, and this was the discussion behind the Mississippi bill that became law in 2020. They chip away at them over time and amend them so that they can make them better. And so we finally got to that point with Arkansas. I think it may have been 4 years ago, I think, where they finally carved out any potential for claims from DHS. But it's finally to the point, and it's finally to the point in Arkansas where we can get comfortable with those. And so what I'm talking about here is these deeds are signed by the vested title owner and recorded prior to their death. But once they pass away, title automatically vests free of any requirement for an estate or affidavits of heirship. It immediately vests in the grantee. They have to be of a specific form that state that they're revocable and clearly indicate that they are a beneficiary or transfer on death deed. But they are revocable. So they can be revoked prior to death by recording a written revocation. In Arkansas, we also view a conveyance by the grantor of the beneficiary deed, a subsequent conveyance to a third party, or a new beneficiary deed. We view that as also revoking the prior. But they're revocable, and the idea is to make sure the property goes to that grantee without them having to incur the cost of a probate proceeding. And like I said, while the grantor can encumber the property with mortgages, they can grant an easement over the property, they can have a judgment lien against them attached to the property prior to them dying. In Arkansas, their estate, their unknown creditors, anyone that would file an unsecured lien claim or claim in an estate, that would not attach in Arkansas. But again, that took years to happen. And so now we primarily look to make sure, were there multiple grantors? Have they all passed away so that title would vest? Making sure that none of the grantees have passed away, and if so, how it would vest then. So we're just looking to see what the facts are at the time of death of all the grantors under a beneficiary deed in Arkansas and the form, and making sure there hasn't been a revocation. In Mississippi, we're not there yet. We have what's called transfer on death deeds, or TODs. So they're very similar to the Arkansas version of beneficiary deeds. They have to meet a certain statutory form. However, the grantor and a transfer on death deed or a transferor can do all the same things as an Arkansas person. They can encumber it with a deed of trust. They can grant an easement across it after the transfer on death deed. They can have a lien attached to it after the transfer on death deed before they pass away. Also, though, once they pass away, the property is still subject to claims of creditors. That has not been carved out. So we have to wait 3 years and 90 days from the date of death of the transferor, or there has to be a probate or administration of the estate to clear that property of claims of creditors. So the thinking there, I know we have a lot of attorney agents in Mississippi. If you're asked about the benefit of a transfer on death deed, it basically, if you want to hang on to the property for a while and you're not going to look to sell it immediately, maybe it would be beneficial then. But I don't know that otherwise it would be beneficial if you're looking to sell that asset not long after mama passes away or dad. Okay. Moving on to divorce issues, because I know we're coming in close to the hour. Not as much with divorce proceedings, although they cause a lot of headache, heartache, especially if we're dealing with a transaction in the middle of divorce proceeding. So some of the issues that come up, homestead interest obviously becomes an issue. While we had some favorable law in Alabama 2 years ago about a homestead property being sold without the non-titled spouse joining, that non-titled spouse was only entitled to the homestead exemption amount. In Mississippi, it would be a completely void transaction. So definitely an issue, especially again, if we're in the middle of the divorce proceeding. If we're in the middle of the divorce proceeding, we're going to have to get an affidavit of abandonment or non-homestead signed by the non-titled spouse. But I'll touch on that a little bit later. There's also the issue of what is marital property. There are several scenarios that I've seen, both in private practice and here with Stewart, where the title vested owner of the property going into the divorce is not the same person awarded the property after the divorce. And in some scenarios, we may actually have a court order in the divorce proceeding saying that the parties are not to offload assets, essentially. That could be considered marital. They're not allowed to sell or convey property. So it's important to look into the divorce proceedings and see where we might be. In Arkansas, again, we have our dower interest, which is basically it's an interest that says if a property owner dies with a spouse, that spouse is entitled to a 1/3 interest as a life estate in all of their property. And so that can be an issue if we're in the middle of a divorce proceeding, even if they say, "Hey, I own the property myself," and it does come up quite a bit. Quit claim requirements and property settlement agreements, divorce decrees, sell out of divorce, whether we need a commissioner or clerk's deed, all of these things come up that delay closings cause problems. I put in here, that's why the question, are you married or single, is more than just a deed prep question. It raises a lot of red flags. The prenup slide. Did he or she sign a prenup? Marital agreements are definitely problematic. I get this quite a bit. My spouse is not signing anything because I got a prenuptial agreement. I'm good. There has been one scenario where I have agreed to insure without a conveyance from a spouse or a signature from a non-titled spouse because of a prenuptial agreement. And that thing was ironclad. It was so well written. I wish I would have kept a copy of it. But generally, we don't rely on those because they are very litigious. They're very problematic. Some of the issues that come into play there is if it's the homestead of the spouse, obviously a huge problem, even if they have a prenuptial agreement. It can be set aside for undue influence, which is generally the argument that gets made to set aside those. Lack of independent legal counsel for both spouses, and of course being unequitable or inequitable. Basically, it's just not fair. Those are all reasons that we see the courts set those aside. So we want to avoid litigation, whether right or wrong, ironclad or not, generally. So we don't rely on those. In a scenario where we have a prenuptial agreement, the parties are butting heads with us, we can typically get by that with the non-title holding spouse to sign a recital attached to the deed saying that they waive any marital, dower, homestead interest that they may have in the property, but they're not claiming any interest in the property. Something that gets the title vested spouse comfortable with them signing off on it, even on the mortgage or the deed of trust. So there are little ways, whether it's an affidavit that we can record, or again an attached recital on the deed or the mortgage or deed of trust. There are little ways that we can usually make it happen. Property settlement agreements. Property settlement agreements can be problematic if they've agreed to it, but it hasn't been incorporated into the divorce decree, because things can change. There are times where judges may, what I think of as overstepping, they may overstep, decide that a property settlement agreement is unequitable, and or there may be some conflict after the fact. As many of you know who have seen divorce proceedings in this scenario, or if you're an attorney agent that's dealt with one, things change from day to day. They may have signed something and then decide that they don't want to show up to the closing. It happens all the time. So we want to make sure that that PSA is adopted and incorporated into the divorce decree. So is this a problem if we're in the middle of a divorce and both parties are agreeable to sign? No, it's, that's fine. If they're both willing to show up and sign the conveyance, there's very limited risk there that a court's going to overturn that conveyance. And so that sometimes is the easiest answer. If they're not going to both join in before or in the middle of the divorce or post decree, then we need to review title, see who was vested with title. We need to look at the decree to make sure that if they were both in title, how the court handled that. Was one party awarded the property and then required the other to quit claim? That could be an issue for third parties, judgment lien creditors who may have not had notice. They could secure their lien against that interest if the quit claim never happened. There could be divesting language in the divorce decree, and we'd want to make sure that the decree got recorded. So how does that end up if we have a situation where one party's awarded the property, but they're both entitled pre-divorce, but there's no divesting language or vesting language in the decree, and the court actually requires a quitclaim deed, which I think is the coward's way out by the judge. I think they don't want to be the bad guy or up their appeals count. If we're in that scenario, then they're going to have to get the quitclaim deed. If they can't locate that individual, they have to file a petition for contempt and get a clerk's deed because the divorce decree, the PSA, were not followed by the other spouse. So there are options there, but they can be a bit of a headache. So here's a general requirement for filing the judgment of divorce and the property settlement agreement if that's what we're relying on because the language is good. Getting divorced. I know a lot of you have asked your seller, hey, are you married? Are you single? And they say, I'm just getting divorced. I know that's a phrase that we all hate to hear. So conveyances during the divorce action, you're either married or you're not, right? So if you're married, we have issues. If you haven't gotten to the point of the divorce decree, We're really looking for both parties to join in so that we're not pulled into a conflict later. And if there's an order that's already come down as part of the divorce, but it's not a final divorce decree stating that they can't offload property, we have to review that and see if we can get comfortable with even with both parties signing in that scenario. We also want to pay attention to who's getting the proceeds if we're not to the divorce decree point yet. There may be a situation where we need to have them agree before they show up to closing how the proceeds are being split to, again, avoid conflict down the line. So sometimes we see drafting errors where we have both spouses that may execute, but it could be questionable as to did they join in granting their conveyance? Was there something in there that leaves open the possibility that they still have some interest? We want to make sure that everything is drafted out correctly and they are either conveying their actual vested interest or waiving, relinquishing any interest, releasing any interest that they may have as a marital interest or a dower interest in Arkansas. Abandonment, missing spouses. I put somebody is signing something. So we have this come up occasionally. If you're not divorced yet, they're vested with title, or we know it was their homestead property. We still need to get an affidavit signed by that spouse that's no longer in the property, stating that they've abandoned it, or they've separated from the spouse and established a new homestead. Depending on the scenario, the fact scenario, we have to have something or be able to get comfortable with risk. So another thing that we're always willing to discuss. Good old-fashioned Southern marriage. So here are some of the state-specific issues that we run into that can come up with divorce, and also some relate back to the estate topic. So common law marriage recognized in Alabama for relationships prior to January 1st, 2017. It still required court recognition, but I put recently came up. Nathan, if you're listening, yes, that was an interesting one. There was a common law marriage recognized that created all types of issues with an estate, to the point of having someone that was not legally married to the decedent being able to work out a settlement that pulled property back into or back through the estate, because the court essentially reopened the estate, set aside the deed from the personal representative that cut out the common law marriage spouse. So that was a fun one to talk through and work through. Arkansas. So Arkansas, this is something that Mississippi thought about adding last year. I'm glad that they didn't. But Arkansas automatically recognizes that title is vested as tenants by the entirety if there's a conveyance to a factually married couple at the time of the conveyance, unless another form of vesting is specified. And yes, I put in all caps, I hate this. It's terrible because it goes against some of it's a conflict. It's a bit of a conflict in the law. So the statutes in Arkansas recognize tenants in common as the assumed vesting. However, case law has gone over that over the years and created this presumption. So they technically don't even have to say in the deed that the grantees are husband and wife. If they were factually married at the time of the conveyance, they take title as tenants by the entirety. It just creates more work for the agent, I've found, because we get to a situation where someone has passed away and they say, oh, well, I was married to that person, the other title vested owner. We didn't own it as tenants in common. We owned it tenants by the entirety. I took the whole interest. Well, the last names may be different. We may not know if they were married at the time. We have to get proof of that. We have to make sure they didn't get divorced at any time. So that's always a problematic thing, and definitely something I opposed in Mississippi when it was talked about. Uh, Also in Arkansas, I talked about dower, curtsy interest, and what that looks like. It does, if somehow back in the chain a spouse did not convey or relinquish that interest, it does fall off. If 7 years have passed with the deed being of record, property was in a third party, it does fall off of that essentially. It's extinguished. Uh, in Mississippi, one thing that comes up from time to time is that a spouse cannot convey a homestead property, meaning not just the homestead exempt property, but their factual homestead property where they're residing, which is always a point of contention because you have to know if they're a multiple home family, what's their primary residence. So a spouse in Mississippi cannot convey under a power of attorney on behalf of the other spouse. That can create a bit of a rub, especially if, and I know some of our competitors take a different view on federal law military POAs. I tend to favor those because federal law will preempt there. But I know that there's a little bit of questionable interpretation on that. Jointly held property. How does it convert when we've had a divorce? How does the vesting change? Well, if it's not specified in the divorce decree that it remains as TBE or joint tenants with right of survivorship. In Alabama, that was changed in 2015 to tenants in common. So I put in here that it was kind of a retroactive change. So what do I mean? Does that law apply to conveyances prior to 2015? It only applies if the grantee under the deed was a third party, a bona fide purchaser. But if it was a related party, then, or if the ex-spouse was still vested with title, then we have to look at who the heirs of the deceased ex-spouse are, because it became tenants in common with the 2015 change in the law. In Arkansas, TBE, joint tenant with right of survivorship, becomes tenants in common. That's been around for quite some time. They beat Alabama to the punch there. In Mississippi, TBE is converted to joint tenancy with right of survivorship unless it's specified otherwise. Again, I hate this. It makes no sense, but it's based off of case law. So yeah, they're going to need to take a look at that at some point. It may change. It's an old case law issue, so it may change sometime in the future as Mississippi continues to look at vesting of title between married couples. Last slide, and then we'll let you go for the day. So underwriting issues post-divorce, we already touched base on some of these. But real property is not addressed in the divorce decree. That's highly unusual and can be problematic if it was a contentious divorce. If it's possible that a piece of property was hidden from the other spouse, there could have been a allocation of a marital interest depending on funds used to purchase the property or maintain the property. So there are some issues that can come up there. If the divorce decree said that the parties have already split their separate property, but it's not specific, we need to take a close look at that as well to make sure that it was not a homestead interest. Real property is addressed, but no quitclaim deed was ever recorded. If it was owned by both parties, if they were both vested with title, that can be an issue with judgment liens or things attaching to the property through the spouse not awarded the property in the divorce decree, and can result in the need for a petition for contempt and a clerk's deed. Real property addressed, but no vesting order into the one spouse. Again, problematic if both parties were vested. We're looking for a quitclaim deed or something to get the non-awarded spouse off of title. Title on both parties, still a judgment liens against the spouse not claiming the property. Touched base on that. Does anyone have any questions? Let me see. I haven't had the chat pulled up.
There hasn't been any in the chat.
Okay.
Anyone
All
before we
right.
let you go? Of course, you can always reach out to Zach with follow-up questions too.
Of course. If anybody wants a copy of the slides, feel free to reach out.
Yes, some have already popped that to me in an email. Feel free to email me.
All right.
See, there's one new message. Great job. Thank you, Michelle.
Well,
All right.
thanks everyone. I hope everyone has a great rest of your last week of the month.
Thank you so much. Y'all have a good one.
Thanks, everyone.
Thanks, y'all.
We'll follow up with that, Mike, on how to get CLE credit.
Yeah, thanks. We'll need it.
Yes, absolutely. Thank you, everyone.